A federal high court sitting in Port Harcourt, Rivers State, has ruled that the Rivers State government, and not the Federal Inland Revenue Services, was the rightful authority to collect value-added tax and personal income tax in the state. Justice Stephen Pam also restrained FIRS, FIRS, and the Attorney General of the Federation, both first and second defendants in the suit, from collecting, demanding, threatening, and intimidating residents of Rivers State to pay FIRS both PIT and VAT. Let's now try to get better educated on this matter by speaking with lawyer and tax expert LANRE AKINSOLA and EMMANUEL, a professor of accounting from Southern Connecticut University in the United States. Welcome, gentlemen. So maybe, good to have you both. So maybe I'll start with you, LANRE AKINSOLA. How groundbreaking is this judgment? Because we know a lot of people have issues around tax collection. And we could see in that suit, they're being restrained from threatening, collecting. Tell us the elements of this suit that many people should pay close attention to.
Okay, thank you very much. I believe, to start with, I believe that the judgment is a positive development for our federalism and our constitutionalism. Nigeria is a federation, and the hallmark of federalism is the division of legislative power between the federal government and the state government. And as we all know, the exclusive legislative lead is where the legislative power of the federal government are enumerated and part of the concurrent legislative lead. Now, the implication is that anything that is not in the concurrent legislative lead and exclusive legislative lead, the federal government does not have the power over such. Now, that's the first implication. The second implication is that anything outside the exclusive legislative lead is within the legislative ambit of the state government. Now, where we have the problem, the origin of the problem is the fact that the law that we are talking about is actually something we inherited from the military. The VAT Act was promulgated as Decree 102 of 1993. So it's the 1999 Constitution, and that's where we have the problem. So instead of using the 1999 Constitution as the benchmark of this law, we are now using this law as the benchmark of the 1999 Constitution. That's basically the problem. Now back to this decision of the Federal High Court of River in Port Harcourt. The implication now is this. The court has decided that VAT is not within the legislative ambit of the federal government. That means it's the residual power for the state government. Now, what is the implication of this? The implication is that anything that is not listed in the exclusive legislative list, in the concurrent legislative list, is within the residual power of the state government. Now, when you look at it, you have taxation of companies in the exclusive legislative list. You have stamp duties in the exclusive legislative list. But there is nowhere where VAT is mentioned expressly or by implication. Nowhere at all. That means it is a residual matter for the state government. And what the Federal High Court decided in Rivers State is actually not novel. What I'm saying is not novel is that the Supreme Court has made similar pronouncements in the case of AG Federation and AG Lagos, and the case of AG Lagos, AG Federation, which I was part of the team that represented Lagos State government. And the argument we made in that case was that what is provided for in the legislative list is regulation of tourist traffic. Therefore, the question of hotel licensing, regulation of traffic does not come within the ambit of federal government. It's on that basis that the Supreme Court of Nigeria upheld the hotel licensing law of Lagos State, as well as a hotel consumption and restaurant occupancy of Lagos State.
All right, Mr. Akinsola, would you permit me to bring in Mr. EMEYONU into this discussion as we try to broaden it further? I would like to find out from Professor EMEYONU. Firstly, my questions in two, Prof. Firstly, I want to find out from you. Do you think this judgment will be appealed, firstly? And secondly, now looking at this closely, we're talking about the value-added tax and the personal income tax. As it stands right now, how will this shake up revenue collection in Nigeria?
Thank you very much, Aaron. I believe that the judgment is most certainly going to be appealed. If you look at what the counsel for the FIRS and the Attorney General of the Federation said, you can tell right away that they're going to appeal the judgment. Secondly, if you remember, before the judgment, some of the issues in contention was the jurisdiction of the Federal High Court in Port Harcourt to try the case. The FIRS and the Attorney General had preference for the appeal court, federal appeal courts, to consider certain aspects of the case, which was opposed by the counsel for the lead counsel and counsels for the River State, and then they ultimately prevailed, both in having the case had in its entirety by the Federal High Court in Port Harcourt. So I certainly believe that the FIRS and the Attorney General are going to appeal the case. With respect to the second aspect of what you said about the impact or the likely impact of this on revenue collection in Nigeria, of course, it is huge, especially at the federal level. That constitutes a good portion of the revenue collected by FIRS up until now. And if this judgment is sustained by the Federal Appeal Court, I do believe it will, eventually get to the Nigerian Supreme Court. And if the Supreme Court eventually upholds this, this is a big deal. This is a big deal. It even accomplishes some of what the people clamoring for the restructuring of Nigeria have been clamoring for. So it's certainly a landmark case. And whether it's appealed or not, I personally applaud the courage of the River State government to go forward with the lawsuit and the courage of the Judge Palm in giving the ruling he gave. It certainly provides an interesting addition to Nigerian case law, especially when it comes to testing the limits of the exclusive and the concurrent list schedules 2, part 1 and part 2 of the 1999 Constitution, otherwise also known as the Decree 24 of May 5, 1999. Thank you very much.
Mr. AKINSOLA, certainly you've heard Professor EMEYONU just stating that this is a major and it's a landmark judgment. But looking at it closely, for a legal practitioner like you that has seen judgments like this happen, let's talk about compliance. Do you think FIRS will comply with the directives and this particular judgment is the big question now?
We are subject to the rule of law, and I believe that there is no reason why Federal Inland Revenue Service, having complied with all and completed all the appeal process, should not comply. There is no reason whatsoever. Every institution, every agency of government, every individual in Nigeria is subject to the rule of law. And provided there is no further appeal, I believe this is a golden opportunity for the Supreme Court. What the Supreme Court failed to do in the case of AG Lagos against AG Federation on VAT, where the Supreme Court declined to entertain the substantive suit, but asked us to go back to the Federal High Court. That is what has now been done. And I believe there is no reason why compliance should be difficult. It should not be.
Okay.
It should not be at all. Thank you.
Thank you so much. Mr. EMEYONU, many people's ears will be pricked at the mention of restructuring, because if we're getting a form of restructuring through the back door, then maybe it's an early Christmas present. So help us understand in America where VAT and personal income tax is being collected at the, you say that where a federation system is being operated and the states are collecting their own VAT. How does it work for the federal government? How do they manage to sustain their own income through other means? What other taxes do they collect?
Thank you very much, Ekene. In the United States, you have the Inland Revenue Service, the IRS. You have the various states' revenue collection. In my own state, the state of Connecticut, you have the Department of Revenue Services. Now, the sales tax, which is the closest to what you get to the value-added tax you have in Nigeria, is the exclusive preserve of the states. The states collect the sales taxes. So because of that, states can outlaw certain activities and therefore will not expect to collect any sales taxes for that. For instance, many states have allowed the sale of recreational marijuana. For instance, some of the states like Nevada, they allow gambling and so on and so forth. So they allow those activities and then they collect state taxes on them. Now, at the local level, property taxes are collected by the local authorities, and they use that for maintaining roads and so on, and they're providing services at the ground root level. So the federal government also collects income taxes. The states also collect income taxes, and you have all kinds of other types of taxes that are collected by those various tiers of government, right? Now, that's in opposition to what we have currently in Nigeria. The Nigerian Federation is just too top-heavy. You have so many things that are concentrated, and some of these agencies are not actually doing a good job of even what has been delineated for them by the Constitution. When you go to the exclusive list, item number 58 there gives the federal government the exclusive right to collect stamp duties, and rightly so. And then, it has other incomes, profits, and capital gains, and so on and so forth. But you tend to find out that over the years, the FIRS, in my opinion, has overreached itself. And you find a similar pattern with many other federal agencies in Nigeria. So from the policy perspective and pragmatic consideration, I think this judgment, it's like I said earlier, it's a landmark judgment. And if all the states will step forward in some of these areas where the federal government seems to be and each agency seems to be overreaching their powers, to test it out in courts, and who knows? Okay. Some of the things being clamored for in terms of restructuring can be accomplished piecemeal.
Okay, very quickly, I just want to throw that to Mr. LANRE. Do you support the view that this is something that could be easily implemented because the laws are in place? It's just the compliance in a few seconds?
Yes, of course. The implication is that there's the difference between law in the book and law as judicially interpreted. Now, the position of the law that we have is what the Federal High Court has decided, and that is the law. Until it's upset, until it's turned as step, until it's overruled, until something is done, that's the law as we have now. And this implication is not only for the Rivers State alone, it's for all the states in the Federation. The implication of this judgment is not about Rivers to collect VAT. It's all the state of the Federation to collect VAT. That's the implication now.
Excellent.
I want to say many thanks to the legal luminaries for shedding light on this latest judgment on personal income tax and also value-added tax. Thank you very much.